Greetings everyone. Once again I would like to welcome every one of you to today's class. And today we want to talk about the law of sale of goods and supply of services. We want to look at the definition and the nature of a contract of sale of goods. When we refer to sale of goods, we are basically referring to buyers and sellers. It's important for every one of us to be involved in a contract of sale of goods. Purpose to sell something on a daily. Purpose to sell something on a daily. For that is the only way you can be able to earn. Avoid monthly emoluments. It is okay for you to have an employment which gives you a monthly emolument. But the people who have made it in life are those who have put in place things which get them what we call daily income. So we are going to begin by defining a sale of goods contract. And it is defined under section 2 of the Sale of Goods and Supply of Services Act 2018, which defines a contract of sale of goods as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. And out of the above definition, there are characteristics which we can look at. That in a contract of sale of goods, there must be two distinct parties to such a contract. That is a buyer and a seller. Another characteristic of a contract of sale of goods is transfer of property. Property means ownership. A mere transfer of possession of the goods will not suffice. The seller must either transfer or agree to transfer the property in the goods to the buyer in order to constitute a contract of sale of goods. What that means is that the seller should transfer his ownership, what we call a legal interest, his legal interest in that property to the person who has bought the said property. That transfer of ownership is what we mean by passing on the property. Then another characteristic of a contract of sale of goods are the goods. A contract of sale of goods cannot exist without the goods. That is why the goods are very important in the contract of sale of goods. Because it's the one which forces the buyer and seller to have what we call a meeting of the minds. So goods are defined under section 1H of the Sale of Goods and Supply of Services Act to include all chattels, personal, other than things in action and money, and all emoluments, industrial growing crops, and things attached to or forming part of the land, which are agreed to be severed before sale or under the contract of sale. Now, under the definition of goods, there are some legal jargons which we need to define. Chattels. A chattel is a movable property. It's a movable property, which you can move from one area to another, like a table, like a chair. Anything movable is a chattel. Now, an emolument is a cultivated growing crop which is produced annually, like coffee, like vanilla, or any other crop that provides yields annually. And then things in action. Things in action may include actionable claims. For example, a bill of exchange, These, together with money, are excluded from the definition of goods. characteristic of a contract of sale of goods is the price. Consideration for a contract of sale of goods must be money, and it is called the price. In a contract of sale of goods, the property is exchanged with money, which we refer to as the price. Minus money, then that is a totally different contract. And a contract of sale of goods may involve either a sale or an agreement to sell, where the property, the goods, is immediately transferred from the seller to the buyer at the time of making the contract. Such a contract is a sale, and where it is futuristic in nature, there is a meeting of the minds between the buyer and seller, but they do not finish the contract therewith, then that is what we refer to as an agreement to sell. Now briefly, let's look at the consequences or results of a contract of sale and an agreement to sell. We want to compare the two. That is a contract of sale and an agreement to sell. You need to know this under the law of contract. As a legal scholar, as a business scholar, you need to understand these comparisons, because it is what is going to help you to be a distinct student from all the others. For you to be a better person, for you to be a better lawyer or a better business person, we determine that through your appreciation of a given principle. And law is basically made out of principles. And those are the ones I'm taking you guys through. So let's look at some of the consequences of a contract of sale and an agreement to sell. So we have the first one as transfer of property. And we are saying that in a sale, there's what we call immediate transfer of ownership. The moment the buyer gives the seller money, the seller will hand over his property, the goods, to the buyer. While in an agreement to sell, it is futuristic in nature. There is a meeting of the minds between the buyer and seller, like a walk to the tailor. You agree over production of a shirt, and you agree on a particular fee. Maybe you will produce it at 40,000 shillings, and then you can give him 20,000 shillings, and he tells you that you will pick it after a week. So that means that that agreement to sell will become a sale at that point in time when you pay the balance of the 20,000 shillings and he hands you the shirt. So that is the main difference when it comes to transfer of property. Number two is risk of loss. In a contract of sale, risk of loss passes together or passes alongside with the object or property bought. While in an agreement to sell, risk of loss may remain with the seller because the contract is not yet fully executed. Number three are the consequences of breach. In a contract of sale, breach may lead to repudiation of the contract because it will go to the root of the contract, and that breach will be of a condition. While in an agreement to sell, it doesn't have to go to the root of the contract, but the party which has breached that contract may be ordered to pay damages. Number four, the right of resale. In a contract of sale, the seller does not have any right to resell. Why? Because immediately after the sale, the property becomes the property of the buyer. While in an agreement to sell, he may sell and pay off the money of the buyer. Insolvency of buyer before he pays for the goods. What happens when the buyer runs bankrupt before he pays for the goods in a contract of sale? A liquidator may be appointed, and the liquidator will help in looking into the assets of the buyer to see whether he can be able to get leverage and be able to pay off the seller. That is what happens in a contract of sale. And in regard to insolvency of a seller, if the buyer has already paid, and the seller is not able to provide the property, the same principle applies. That a liquidator will be appointed who will help in gathering the properties of the seller to see to it that he can be able to get money so that he can be able to pay back, or he can be able to buy the property which the buyer paid for. So that is how such is handled. Now briefly, let's distinguish between a contract of sale and other types of contracts. There are a number of contracts. Now we want to differentiate between a sale and other types of contracts. There are so many contracts in law and business. So as a student of law, as a business scholar, you need to differentiate between some of these contracts. And allow me to take you through these contracts. So I'm going to begin by comparing a sale and a hire purchase contract. A sale, like I said, there is immediate transfer of property. The property exchanges with the goods, money exchanges with the goods. While in a hire purchase, someone may hire a property with an option to purchase it later. He may even pay for the property in installments and may finish paying for it like after a year or a month. So meaning that that property will officially become his at the payment of the last installment. That is when it will become a contract of sale. So briefly, that is the difference between a sale and a hire purchase contract. And then we have a sale and a barter trade type of contract. In a sale, a good exchanges with money, which we refer to as a price. While in a barter trade type of a contract, it is where a good exchanges for another good. Someone wants a plot of land, but he doesn't have the liquid cash. So what does he do? He gives out his car, and then he's handed a plot of land. Then we have what we call a sale and a gift. A sale has what we call a money exchange with a property, and gifts are on a personal reason, whereby there is a person who gives out the gift, and the other person, all the other person has to do is to accept the gift, which we refer to as natural love and affection. Then we have a sale and a bailment. A sale, one gives you money and you give him the good. In a bailment, it is an arrangement between A and B, where, for example, A may give B money to help him finish off something for a period of a month. But after the lapsing of the month, B will have to return the money which was given to A, which was given to him by A, back. He bailed him out with money to finish off a project, but he's supposed to pay back that money. Then there is a sale of goods and a contract of supply of services. Now, in a sale, there is immediate transfer of property and money exchanges with the good, while in a contract of supply of services, one is paid for the service offered. Like what I'm doing now, I'm offering you guys a service. So if I'm working for someone, he will definitely have to pay me for that service. And lastly, we have a sale and a contract of agency. In a sale, there's immediate transfer of property and money exchanges with the property, while an agency is an arrangement where a principal appoints an agent to help him in dealing with his service with a third party referred to as a customer. So in an agency, there are three parties. There's a principal, there's an agent, and there is also a third party whom we refer to as a customer. Let's look at the terms in a contract of sale of goods. Terms, some of the paragraphs, some of the basics, some of the primaries, which are supposed to be in a contract of sale of goods. Now, these fall under two categories. We have a condition, and we are defining a condition as a stipulation which is essential to the main purpose of the contract, breach of which gives the aggrieved party a right to repudiate the contract. In addition, the aggrieved party may maintain an action for damages for loss suffered due to non-performance of the other party's obligation. So a condition goes to the root of the contract, breach of which may force one party to call off the what? The contract. Now, a warrant, on the other hand, is a stipulation which is collateral to the main purpose of the contract, and breach of which gives the aggrieved party a right to sue for damages only and not repudiate the contract. Let's look at some implied conditions. Paragraphs which are supposed to be a must in a sale of goods contract. Number one, title. Title is basically ownership. You can only sell that which you have ownership over. You can only sell someone else's property if you have what we call in law powers of attorney. If you're selling a plot of land, you should have an agreement which shows that you are an owner. And if you do not have the agreement, you should have a certificate of title with your name on it. That is conclusive evidence of ownership, which means that you have a legal interest in that property which you are selling, not an equitable interest. So that's what title is all about. Number two, description. You cannot sell something which you cannot describe. If you're selling a plot of land, you're supposed to know its size, that it's a 50 feet by 100 feet piece of land, situated at Mukono or any other town. That's what we mean by description. And then sample. There are instances where the buyer goes to the seller with a sample. It may be a shirt, 100% cotton, and he tells the seller that I want 100 more shirts like this. So you have to make sure that you provide the buyer with shirts which are similar to the sample he presented to you. Very important. Number four, fitness or quality. The good that the seller is giving out or selling to the buyer should be fit for the purpose. It should serve the purpose. It should serve the purpose for which someone is buying it for. Very important. And lastly, examination by the buyer. There are instances where the buyer may seek to examine that which is taken. So when he seeks for that, the seller is supposed to give him the benefit of doubt so that he can go ahead and check that which is taken. It's very important. It's very important. And lastly, let's talk about some warranties. A warranty of quiet possession. When you buy a piece of land, you're supposed to use it without any encroachment from the buyer. Number two, free from encumbrances or third-party claims. That when you buy a property, it should be free from any third-party claims. It's very important. It's very important. And lastly, particular purpose by usage or trade. That which you bought should be used for that particular purpose as a tool of trade. Once again, I would like to thank you for watching. And don't hesitate to subscribe to my YouTube channel, Luteete Mikka, where there are many more videos on life, on business, the legal perspective, and may the good Lord bless you all. Thank you.